Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. So today's topic for discussion would be on comparative analysis between procedures in domestic and international arbitration. And joining us today on our channel is somebody who needs absolutely no introduction in the field of arbitration. She's someone who is excelled in the field of arbitration and adorned two arbitral hats, both under the English law as well as in the Indian law. She is a dual qualified lawyer specializing in cross-border commercial disputes, and she's achieved a lot in the field of arbitration, both in India as well as in the UK. So today on our channel, we are in conversation with Ms. Chinmayee Pendse, who's an advocate in India and solicitor, England and Wales. And just to give you all a brief introduction about her amicus for today's session, Chinmayee is a dual qualified lawyer specializing in cross-border commercial disputes under English and Indian law at the chambers of Karishma Vora in Mumbai. With 8 years of experience, she has represented clients in ad hoc and institutional arbitration seated in London, Singapore, Dubai, under the auspices of the LCIA, ICC's, SIAC, LMAA rules and commodity arbitration, such as under the LME, RSA, and SAL rules. She's conducted proceedings with a focus on commercial disputes before Honorable Bombay High Court, with deep exposure to oral advocacy, drafting, pleadings, and conducting cross-examination. She's also defended interim applications, challenges to domestic arbitration awards filed against leading real estate and infrastructure companies in India, the decisions of which have translated into reported judgments. Her experience in arbitration, and especially in the domestic field, includes representing parties in ad hoc arbitrations and arbitrations conducted before the National Stock Exchange. She's also a member of the Chartered Institute of Arbitrators, United Kingdom, and serves on the core committee of CIARB's Young Members Group in India. She was also part of the drafting team of the second version of the Indian Arbitration Forum, the IAF, guidelines that were published in 2020, and also acts as a tribunal secretary on international arbitrations. She's frequently invited as a guest speaker for workshops on international arbitration organized by various institutions, including CIB's Global Young Members Group, and so on, and the list goes on and on. She's also an alumni of Government Law College Mumbai and has a dual master's in international business law from the London School of Economics and Political Science, University of and Mumbai. So thank you, Chinmayee, for taking out time for readily saying yes for a session on our channel. It really means a lot. And really sorry for spoiling your weekend plans. So anything that you wish to say about our channel before we quickly start with our session?
Absolutely, Jai. Thank you very much for such a warm and long introduction, I must say. What I really want to say is that the virtual amicus, I was going through your YouTube channel before getting on the talk here, and I can see that you've had sessions on such varied topics, and it has been so informative for everybody who has access to your platform. Because when I was growing up and when I was in law school, I did not have these kind of opportunities and all of these accesses to various points of law, other than probably reading books, doing internships. There wasn't really material out there on how to do LLMs in various different law schools, or niche topics, and experienced speakers coming and giving conversations and talks on everything, that they are experts in their particular field. And I think it's so impressive that now, because of the virtual amicus, students and young practitioners and lawyers have that access because of you. So it's quite commendable for what you've started, and I'm very glad to be a part of this today.
Well, thank you for all the kind words. To all the viewers who are watching, the endeavor has always been not only to solve legal issues, but also to create legal awareness and to do it in a way that is easy for everyone to comprehend and understand it. So, Chinmayee, if you're ready, shall we start with our session?
Yes, absolutely. Let's dive in.
So, before we dive in, I have one question for you. How and why did arbitration happen, and how did you end up with arbitration law?
Jaya, I think the answer to this, I'm afraid, is not very straightforward. I did not start my legal career thinking that I want to do arbitration or I want to be a cross-border dispute specialist. I did a moot when I was in law school, which ran around arbitration and contract law. That got me interested in arbitration. And it so happened that all of the internships I did thereafter had some element of arbitration matters that I was put on as an intern, which sort of got me interested in arbitration. And then it sort of so happened that when I did my master's abroad at LSE and I joined my senior, who is a dual qualified barrister, she specialized in cross-border disputes, and about 70% of her practice was also, international arbitration and cross-border commercial litigation. And I just stumbled upon this field. So I think I consider myself very fortunate to have sort of found this specialization so early on in my career. But if in my first year and first day of law school, if I had started with saying, I want to be a cross-border dispute specialist under Indian law and English law, I wouldn't know where to start and how to sort of build my career. What I did was I grabbed every opportunity that came my way, gave my 100% to everything, and then the path sort of just got laid out for me. So what I would tell everybody who probably wants to specialize in arbitration is take each day as it comes, grab every opportunity that comes your way, and when the time is right, you will find your path.
Yes, eventually things do fall in place. So let's quickly start. Can't wait for this session to start. And
Sure.
so if you can differentiate between domestic arbitration and international arbitration, as well as ad hoc and institutional arbitration for all the viewers, and if you can talk us through different applicability of laws, the governing laws, the law of seat, etc.
Sure. I think let's just start with basics first. What
Yes.
is arbitration, right? Before we get into different kinds, right? So, arbitration is when two parties decide to adjudicate their disputes by help of a neutral third party who is called an arbitrator in arbitration, and whose decision, which is called an award, not a judgment, is binding on the parties. So that is a framework which is an alternative dispute mechanism to court, where parties decide who they would want their dispute to be adjudicated from. Now, between domestic and Indian arbitration, there are two kinds of arbitration: domestic and institutional, and then domestic and international, and between them, ad hoc and institution. From an Indian perspective, a domestic arbitration would be an arbitration between two Indian parties where their contract is governed by Indian law. So, that is a purely domestic arbitration from an Indian perspective. Similarly, if you're in London, a domestic arbitration in the UK would be an arbitration between two English parties governed by English law. So, and that's the same for every country. So that is your domestic arbitration. Your international arbitration, however, is when one party, well, let's do it from an Indian perspective right now. So, Section 2F of our Indian Arbitration Act defines what an international commercial arbitration is. It is where at least one of the parties is an individual of a national of any country other than India. Or if it's a company, then it's a company incorporated in any other country other than India. Or if it's a government of a foreign country, or an association or a body whose central management is outside of India. So essentially, from an Indian perspective, an international commercial arbitration would be where one party is a foreign party and one party is an Indian party. And the seat of the arbitration then in this case would be India, but I'll go to seat and the governing law when I get to the applicable laws. Now, this is domestic and international arbitration. Now, let's speak about what is an ad hoc and an institutional arbitration. An institution arbitration is where there's a separate institute which sort of helps you and takes on the role of administering your arbitration. So what they will do is that every institution will have its own set of rules, and those rules will determine your framework of your arbitration. So, for example, appointment of arbitrators, timelines for pleadings, your fees of the arbitrator, the timeline for when an award would be made. So the rules will essentially govern the framework of your procedure. Whereas in an ad hoc arbitration, this is an arbitration without administration by any institution. So it is the parties and subsequently the arbitrator who's appointed will have complete autonomy on the rules and the fees of the arbitrator, the framework of the arbitration. So the procedure is completely determined at the discretion of the parties and then the arbitrator. So that's your primary difference between an institution and an ad hoc arbitration. Some examples of institutions you probably the audience would have picked up from my introduction. So MCI, LCI, CAC, ICC, these are all institutional arbitrations. It is not necessary that you need an institution to govern your arbitration only if it's an international arbitration. A purely domestic arbitration can also be governed by an institution. So, for example, two Indian parties can choose that they will have maybe a sole arbitrator decide their disputes, and their arbitration will be governed by the rules of the MCI, for example, which is the Mumbai Center for International Arbitration. So that will, there are advantages of having an ad hoc versus an institutional arbitration, but we can probably discuss that when we go through each stage of the arbitration. So that's insofar as the different types of arbitrations are concerned. Now I'll move on quickly to the various applicable laws. In a domestic arbitration is fairly simple. So if it's a domestic arbitration, what you generally have, there are four kinds of rules or laws, broadly speaking. One is a governing law, one is the law of the seat, the third is the law of the arbitration agreement, and fourth is the rules of the institution. So we've discussed the rules of the institution just now, where I said that the rules of the institution will sort of govern your procedural framework, so to say. Governing law is the law of your main contract. So if it's a sale of goods, for example, if the main contract is governed by Indian law, then whether or not, the quality of the goods was right or whether the payment was made, all your substantive issues under the contract would be governed by the governing law of the contract, whether it's Indian law, English law, Singaporean law, or whatever it is. The law of the seat is where the legal seat. A seat is different from venue. We all know that. Seat is the country in which your arbitration is legally seated. The seat is important because if you have if you need court intervention, then you go to the courts of that seat for any intervention from courts, for any interim reliefs if required. Or if you want to challenge any award, a challenge will only happen at the law of the seat. So from a domestic perspective, let's look at it from this way. So you have Indian parties, your governing law will always be Indian law. Your seat generally tends to be, say, maybe courts of Mumbai will have jurisdiction, or courts of Delhi will have jurisdiction, or say, courts of Hyderabad or Rajasthan will have jurisdiction. So in that case, if you need any assistance, you can have venue, you can have your arbitration virtually like this. But if you need any help in terms of court intervention, you'll go to the court of that state in India, and your arbitration award, once it's given, it will be challenged in that particular courts of those states. So that is the law of the seat. In a international perspective, it would be the courts of those countries instead of courts of those states. So that's the difference. And the law of the arbitration agreement is essentially, sometimes it so happens that the parties can choose to have a law govern their arbitration agreement, which is different than your main governing law of the contract. It's always advisable to have it same, because otherwise it creates a lot of confusion. But what the law of the arbitration agreement essentially does is that it tells you whether or not a particular dispute is arbitrable. So the law of the arbitration agreement tends to cover arbitrability of an issue. So, so these are the four kinds of rules or laws: governing law, rules of the institution, law of the seat, and law of the arbitration agreement. So that's your basics. Once you get that, then you get to procedure.
Very well now. And we're talking about, initiation of arbitration, particularly from the international institutional perspective. So as far as domestic arbitration is concerned, we are all well aware that a notice under Section 21 is mandatory. So there's a mandatory requirement of serving a Section 21 notice before referring the dispute to arbitration. And this is prior to obviously filing a Section 11 application through which the court appoints an arbitrator. Now, talking about institutional arbitration, if you could talk us through how a notice has to be given under what provision of law, and how different it is from domestic ad hoc arbitration. So basically, how is it initiated in the first place? And once
Right.
it is initiated, then how does the appointment of arbitrators takes place? Is it in the form of a panel? Is it in a form of, let's say, is there a sole arbitrator, or there are more than one arbitrators? So if you could, explain this whole process.
Sure. So, like you rightly said, in our domestic Indian arbitration proceeding, you would issue a notice of arbitration under Section 21. So you would write to the other party saying that this is my dispute under this is the arbitration agreement. This is probably the arbitrator I want to nominate, and you either give consent if it's a sole arbitrator, or this is my nominee arbitrator, and you appoint your own arbitrator if it's a panel of 3 arbitrators. The process is more or less the same when it comes to international commercial arbitration, governed by, or a domestic arbitration, or even a domestic Indian arbitration governed by an institution. But what the terminology is slightly different. So instead of a notice of arbitration, what you would send is a request for arbitration. It's called an RFA. And a request for arbitration looks slightly different from a notice of arbitration. So a notice of arbitration, like I said, would have your generally your dispute, your section, and your arbitration agreement clause, and your nominee. But in an RFA, if which you would issue under the rules of most of the institutions in an institution arbitration, they have their particular requirements of what RFA should have. And a lot of it is you would start generally with the contact details of the legal representatives, the parties, and then you would probably set out what gives you the right to go to this particular institution and initiate. So you would set out your arbitration clause, you'll give details, and then you'll give details of the arbitrator who you want appointed, and you'll talk about fees. For example, fees of this institution have been paid, or whether we'll pay it in some time, and then you will say how you will serve this RFA. So you issue a request for arbitration, give it to the institution, and then you serve it to the other side. So that is how it sort of proceeds in terms of initiating an arbitration under an institution setup. Let me share with you, Jai, how a RFA would probably look like. This is commencing an arbitration under LCIA. If you can sort of look at my screen. So you would sort of have a header. This can, of course, be on a lawyer's letterhead, but you sort of have a title on top. And then, like I said, it will have contact details of the parties and their authorized representatives. So it may or may not be in form of a table, so long as you have all of this. And then you would have your claims and the nature of the dispute. And then as we go down, you'll say under what, pursuant to which article of those institution rules, you've initiated this. You'll say what the seat of the arbitration is, language, governing law. You'll set all of this. You'll give the name of your nominee arbitrator. You'll speak about the fees. You'll, say that whether or not this RFA has been served or whether you'll serve it. And then, of course, you'll end it. So you'll see that this is slightly different from your Section 21 notice, but it essentially does the same thing. So what you need to do is communicate that a dispute is arisen and you want to arbitrate. So the purpose of both is the same. It just the format is a little different.
Fantastic.
And yeah, and I think just to answer quickly your next question about how an arbitrator is appointed, from an Indian perspective, domestic ad hoc arbitration, what will happen is you will send your notice of arbitration. If it's if it's a panel arbitration, then it's no problem, because you'll say that this is my nominee arbitrator. The other side will come back and say this is my nominee arbitrator, and then those 2 arbitrators will appoint a 3rd arbitrator if the arbitration clause seeks for a 3-panel tribunal. But if it's a sole arbitrator, that is where we have problem in India, because if it's a sole arbitrator, in your notice of arbitration you'll nominate a name. The other side will obviously 100%. I've never seen a matter where the other side has willingly said, okay, let's give an arbitration to this person, right? So other side will obviously object, give another name. You will not agree to it because you don't know why the other side has suggested this. So typically in an ad hoc arbitration, when the parties don't agree who the sole arbitrator would be, you have to file an application under Section 11. This Section 11, of course, will be filed in the court of the seat. So whichever state in India where the arbitration, the courts have jurisdiction. under international commercial arbitration, of course, it will go to the courts of the country, and the arbitration act of that country will have sort of power in terms of adjudicating and appointing an arbitrator from an ad hoc perspective. But this entire process can be completely done away with, of going to court for an appointment of an arbitrator, if you have an institutional arbitration, whether it is a domestic arbitration or a ICA, an international commercial arbitration. Whether if it's an institution arbitration, and if the parties can't agree on a sole arbitrator, then the parties just write to the institution, and the institution appoints it, the arbitrator. So in 99%, even if you give your nominee arbitrator, it's quite likely that the if the other side doesn't agree, the institution will just appoint an arbitrator. And in a cross-border situation where parties are from different of different nationalities, depending on which institution is governing your arbitration, those institutions also have rules on appointment of arbitrators, where it would be that the institution will say that the arbitrator cannot be of the same nationality of the party. So if there's a dispute between an Indian party and say a Taiwanese party, then maybe the arbitrator will have to come from a neutral nationality. So maybe a Singaporean or a French arbitrator or an English arbitrator. So all institution rules have their different rules in terms of the nomination of an arbitrator. But the good thing about having an institution arbitration is that you skip the entire process of an equivalent of a section 11 to go to court for an appointment. So it's fairly quicker, because the institution is able to appoint an arbitrator, say maybe within a week, as opposed to you going to court and at least waiting. Even in a quickest forum in India, it would at least take, I'm presuming, a month for a Section 11 to be adjudicated. So that, I would say, is a benefit of an institution arbitration over ad hoc, certainly, because the whole appointment of an arbitrator becomes quite easy.
Yeah, in fact, unfortunately, constitutional courts are flooded with Section 11 applications, and there's a huge pendency. It takes on an average 2-3 months to decide and adjudicate upon. I think that way, institutional arbitration, anyways, would have an edge over ad hoc arbitration.
Correct.
You don't have to go through court procedure for appointment of an arbitrator, and that is where the rules are enshrined, and in-house rules govern everything. The practice and
absolutely. So the framework of an arbitration is sort of controlled by the rules of the institution, and therefore it sort of streamlines your arbitration process.
Yeah. So on a lighter note, any particular institutional arbitration forum that you have preferred, conducting arbitration proceedings, that you feel is thoroughly professional, that we should seek inspiration from and, learn from?
I think, well, I have arbitrated in front of most of the main arbitral institutions like MCI, LCI, ICC, SIAC, and I think all of them have their advantages and disadvantages, but generally all of them are thoroughly professional. So all arbitrations are conducted in a really efficient manner. So there's no difference, so to say, in between the conduct of an arbitration in any of these institutions. I will like to say, though, that in recent times, I've heard the Mumbai Center for International Arbitration is doing a great job in appointment of arbitrators, where they're giving priority to female arbitrators, and really encouraging young lawyers to be appointed as arbitrators, and industry specific non-lawyers, if they are experts in the field. MCI is promoting appointing those non-lawyers also as an arbitrator. So I think it's a great initiative by an Indian institution to sort of promote different players in arbitration. So I certainly I would want to say that it's a great start for arbitration in India.
Yeah, and I think it's very important to identify that pool of arbitration specialists, especially in the bar, so as to identify the best possible lawyers who can be arbitrators and who can contest a lot of arbitration matters. There has to be a designated bar for that. And that is also very important, so that they can be groomed. And a lot of disputes on the commercial side can be adjudicated upon meritoriously and properly.
Yes, there's been a lot of talk about creating an arbitration bar in the country, so that arbitration is not just a 5 to 7 procedure that people do
Exactly.
after court, and you can have it, a full day arbitration. So if there's a arbitration bar that only does arbitration, so
Exactly.
there's been a lot of talk about this, and I'm sure the way arbitration's progressing and the stance India has taken in a pro arbitration way, I'm sure the day will come sooner rather than later.
Yes. So now going ahead with our next topic, and I think this is the most important part, the most important feature of any arbitration, the hearings that are conducted. How different are the hearings conducted there, different from the hearings that are conducted here? If you could talk us through the interim hearings before the seat court, how is an emergency arbitrator appointed, etc.
Sure. So I think the way interim hearing works that okay, let me take a step back and say that when you initiate an arbitration, there are times when you need urgent reliefs from the forum, right? So there are 3 ways that you can get those urgent hearings or interim hearings or reliefs from the forum. So the first is you apply to a court for interim hearings even before an arbitration has been initiated. From an Indian context, you will file a Section 9 in court for an interim hearing. Similarly, if your arbitration is seated abroad, say maybe in England or in Singapore, and if you need urgent interim hearings, you would go to the courts, you'll apply the Section 9 equivalent of those arbitration acts and go to those courts for interim hearings. And of course, those interim hearings before court will progress just as way as any court hearings there would progress. So in India, you're able to get a Section 9 reliefs very quickly. That's similarly the case abroad. So there's not much of a difference. But you can get an audience to court for such interim hearings only if prior to the commencement of an arbitration. So once an arbitrator has been appointed and the arbitration has started, then you have to go to an arbitrator that you've appointed for an interim relief. So in this case, from an India context, you will have to file a Section 17 before an arbitrator for an interim reliefs. Similarly, in UK, you will have similar provisions for application for interim hearings before the arbitrator. Similarly, in Singapore or in France. Recently, what has happened is that to avoid going to court and to avoid the time lost in actually selecting an arbitrator and the arbitration to progress before you make any application for interim hearings, a lot of institutions have created this concept of what is called an emergency arbitrator or an EA, where the institute, if you need urgent reliefs from an emergency arbitrator, you write to the institution to say that I need urgent reliefs under this contract. You appoint an emergency arbitrator, and that emergency arbitrator will give you a hearing and give you interim reliefs. And then once that is done, your actual arbitrator will be appointed. So essentially, the EA does the job of what a court will do for you, right? And an EA is appointed within a span of 24 hours, and a hearing can be sort of organized before the EA very quickly, and an award will be given very quickly. So I think what the institutions have tried to do is sort of see if an EA's award is, delivered quicker than a court award, then, parties will probably prefer going to an EA to get their interim reliefs. The difficulty, however, actually both from an interim court proceeding hearing or an EA award is the enforceability. In India, it's still okay because now India has recognized an emergency arbitrator from an Indian seat perspective in Amazon versus Future. Interim hearing court awards in a court judgments in a domestic scenario can of course be enforced. But when you go abroad and when you have a foreign seat, for example, if an interim award is given in Singapore or interim injunction is given in Singapore, then how do you enforce that in India is a big question. Similarly, if it's an interim award given by a tribunal under the New York Convention, only final awards can be enforced outside the jurisdiction, right? So if you have, for example, an emergency or an interim award given by a tribunal seated in Singapore and you have to bring it to India, the only way to enforce it is to file a Section 9 and have it enforced. So that way, if the other party is not somebody who is going to abide by the EA's award, then you are sort of stuck because you eventually have to go to court for enforcement in another jurisdiction. So you lose time and energy doing that. But also at the same time, if it's an EA award, what happens is if the other party against whom the award is made doesn't comply, the party knows that after the EA there is going to be an arbitrator stage. So it's an adverse implication that will fall on the party if they don't abide it. So it's in that sense a strategic decision for lawyers to sort of advise the parties whether they should go to court for an interim injunction or they should go to an EA, or then you wait for the tribunal to be constituted and then go to the formal arbitrator tribunal for your interim relief. So depends on at what stage you need interim reliefs, how quickly you need them, and how you would need to enforce it. All of those would need to be taken into consideration when you advise your client on which of these three processes you should take.
Very well now. And we're now talking about pleadings. So what possible timelines are set by these institutional arbitrations, and what exactly is the content of pleadings that are required to be? So are facts need to be pleaded, or is it the law of the land that needs to be pleaded? Does it have to be very dispute specific, or is it have to be law specific? And what exactly do we mean by we keep hearing this, that there's a procedural order? So what exactly do we mean by a procedural hearing? If you could talk us through.
Sure. Okay. So we've covered the stage until where an arbitrator's been appointed. Now, when an arbitrator is appointed, what next? How do you start your arbitration, right? I mean, technically, your arbitration started as soon as you give your notice of arbitration or your RFA. But once the arbitrator is appointed is actually when you start, filing your claim, your defense, all of it. So what are the timelines for this? Who decides it? All of that in an ad hoc arbitration or ad hoc domestic Indian arbitration will be governed by what the arbitrator decides, because there are no set frame rules. So what the arbitrator will do is he'll schedule what is called as a preliminary hearing, and he will both lawyers will sort of attend that hearing, and then the arbitrator will say that, okay, you file your claim in 30 days, you file your defense in say 30 days. If there's a reply or counterclaim, the arbitrator will sort of give the early directions, so to say, for up to the pleading stage in a preliminary meeting, and then that would be recorded as a minutes of meeting in a domestic arbitration scenario.
Yes.
The same thing in an international commercial arbitration abroad, what they call it is a procedural hearing, which is the first. So instead of a preliminary meeting, the terminology is a procedural hearing. And any decision out of that procedural hearing is called a procedural order. All orders, in fact, until your main award, if there are multiple hearings before the tribunal, then they're titled procedural order 1, 2, 3, 4 in an international commercial arbitration. In India, they're generally just minutes of meetings or interim orders if it takes a form of an order. In case of a procedural order, though, in a ICA situation, it covers not only your pleading stage, it will have a timetable until the end of the hearing. So I think what I enjoy about international arbitration over domestic arbitration is that on day one, you know how your arbitration is going to progress. And adjournments are not given lightly, because the more adjournments you take, then the timetable needs to be sort of reworked. And then you don't have that kind of sort of gaps between the two timelines, so to say, to sort of maneuver your way around. So you know 100% on day one that about 90% of the times that this is how your schedule is going to be and this is how you're going to have your final trial and evidence, which is not the case in domestic arbitration, because what tends to happen is that as Indian lawyers, we are so overworked that we try to seek adjournments whenever possible. And then obviously the tribunal has to comply, because if the tribunal doesn't comply, there are due process challenges that are likely to happen to an award for not opportunity not being given, etc. So it tends to drag on. And then, which is why timetables are probably set through multiple hearings, multiple preliminary meetings, so to say, and then only the next stage is sort of decided. So there are more hearings, so to say, in a domestic ad hoc international arbitration, as opposed to an international commercial arbitration or an institution arbitration where everything is set from get go. So you tend to only be before a tribunal at the stage of your PO1 if you need any interim reliefs, and then directly a trial. So there are only like 3 or 4 hearings that happen in an ICA, as opposed to maybe 10 or 12 that could happen in an ad hoc arbitration before you get to trial. So that is in that sense a benefit of an institution arbitration, or even an ad hoc arbitration that's conducted abroad in an ICA situation. And let me just quickly show you how a PO would look like.
Yes.
Um, so this is, for example, a procedural order.
Yes.
You will of course have all of the titles, and you will see that it's titled as a procedural order 1. You will have the name of the tribunal. You will have the registry. So here the registry. So this is a tribunal constituted under the Permanent Court of Arbitration. And so if it was the LCI or the ICC, it would have the details of LCI, ICC written here. A tribunal secretary is also a concept which is internationally more common than in India, where you have a secretary or tribunal secretary appointed to assist the tribunal with day-to-day functions of coordinating with the parties, setting timelines, or assisting with documents, etc., which is not really common for domestic ad hoc arbitration. So you'll see you have coordination of proceedings, timeline for submission of preliminary issues if there are any, and then you'll see how the timeline is sort of set for everything from submissions to production of documents, outstanding issues. Then you'll have case management meetings up to oral hearings. So if you look at the third last column, so oral hearing is your final trial. So parties need to tell them how long the trial is going to take. So on day one itself, which is very different than what you would have to do in India. And then these 10 days sort of don't change, right? So you need to ensure that all your arguments, everything sort of fits within those 10 days. And then after hearing, you've post-hearing submissions and any submissions on costs. So this is what is sort of decided on the get-go from the first day itself. And then there are, of course, detailed orders on how evidence is going to be taken. In heavy international commercial arbitrations, there are so you will see how documents are to be submitted. So, for example, if you look clause 6.3, it says each exhibit submitted by the claimant shall commence with letter C, and then it would be give a consecutive number. So, the tribunal sets out in extreme details as to how everything needs to be filed as well in the format in which it needs to be filed, which is not the case here in a domestic scenario. Also, details about how witnesses are going to be examined, if there are expert witnesses, how it's going to happen, all rules up to the end. So up to post-hearing submissions, costs, everything is set out. Of course, there are directions on confidentiality, transparency. Your governing law, your seat is generally set out in your procedural order. So this is how a procedural order in an ICS setup would look like. And let's just compare it to a preliminary meeting in a domestic scenario and how it looks like. So if you can see, I've redacted, of course, the names of the parties and the tribunal, but you'll see that the tribunal was a former judge of the Bombay High Court, and this was a sole arbitrator. You will generally have the names of the parties. You will have appearance here, as in who appeared. And then you will see it's not titled Procedural Order 1, but it would be minutes of a preliminary meeting that's held. And then the tribunal will generally set out here what the dispute is, a brief about what the dispute is, and then how the tribunal was appointed. Because in India, what tends to happen is you generally go to court for a Section 11 for a sole arbitrator. So then you'll see in para 2 that it says by order dated so and so, I was appointed as a sole arbitrator. So the tribunal will write down how the tribunal was constituted. Then, of course, you will have all of the communication set out in the procedural order, like who are the advocates for the claimant, advocates for the respondent, communications for like the email addresses, contact details of the tribunal. And then you will have, if there are interim issues that need to be filed, then the tribunal will say as a paragraph that within 4 weeks from today, the claimant will file an application for Section 17. So it's not, it's set out, but not in a tabulated form. And then you will see in the last paragraph that a next meeting is fixed at the same venue. So it's very much like you cover one stage in one meeting, and then you have a next meeting set out to decide the next stage, as opposed to you will see in the PO1 that we sort of read, which was everything is just set out from the get-go. So that's, I think, is a major difference in which arbitrations are conducted here domestically. Ad hoc arbitrations are conducted in India as opposed to how arbitrations are conducted abroad.
Very well, Phil. Thank you so much for that elaborate, description and the way you explained it through this presentation. I mean, I'm sure to all the viewers who are watching, most of the queries must have been solved by now. Vis-a-vis how the procedure of hearing is conducted, what exactly is a procedural order, how are timelines stipulated. But I must say that, the way everything is done at an institutional arbitration level, it is also professionally done. All the timelines are crystal clear. They're stipulated, explicit about when the next meeting will be and what are the deadlines that are required to be met. So I think it is all done very professionally. Now, talking about affidavit of evidence and written statements, if you could please guide us through as to do documents really require to be notarized, or that stage is totally not required at all? Is there a requirement when you talk about international arbitration? And talking about the pre-trial stage, is there a timetable that is given or handed over to the parties in advance? Is it done electronically or through paper? How does it go about?
Thanks for the question, Jai. But before we get to this pre-trial stage, I think it's quite important for the audience to know how the previous stages work, because they're slightly different in domestic arbitration than in international arbitration. So pleadings, as you'd asked me in the previous question, there, of course, we all know, even in India and in abroad, pleadings will always, you plead facts and not the law. But what I've learned over the years of my practice of doing international commercial arbitration or even commercial litigation abroad in the UK, pleadings are far more succinct there than they are in India. So, for example, all of the unnecessary words, all of the Latin, it all goes away. It's simple, plain facts that are pleaded connected to the law, but you don't plead the law. For example, unnecessary words, like when we file anything, you would say it is submitted that, or the claimant submits, the respondent submits. All of those words are sort of given away. Or things like when you say that at the beginning of a defense, you would say that the claimant is guilty of suggester, falsy, suppressor, very, all of those standard things that you write in a defense at the beginning, all of those are sort of gone away with. You don't say that, you don't really talk about, balance of convenience. All of that is sort of, it's set out, but not as in a verbose manner as you would set out in an Indian pleading. So when I did start my practice, there's a little anecdote that I would like to share. So I was asked to draft a pleading by my senior when I was a mini pupil at 4 and 5 Grayson Square many years ago. And in India, I thought I was reasonably well at drafting, although I only had about 2 years of experience. And then I took a break for 1 year for my master's before I did this mini pupillage. And I thought, okay, itna bura nahi hoga. It won't be that bad, whatever I've drafted. So I sort of, took my draft to my senior. She looked at it, flipped pages, and she said, it's nice, but it's very Indian. And I didn't know what that meant. And then my entire process of unlearning started, where I had to sort of learn the English way of doing things, or rather the international way of doing things. And you sort of, when you're doing domestic work here, you still have to sort of switch to try and do it the way Indian courts do it, or Indian arbitrators would want your pleadings to be. But in an international perspective, it has to be extremely to the point and short. So if I'm saying something in 10 pages in an Indian pleading, I would have to say the same thing in, say, maybe 4 pages abroad. So that is something that I think, as Indian juniors and Indian practitioners, we also need to sort of take a step back and see whether we can sort of make our pleadings crisper, rather than, just rambling on for pages and pages trying to say the same thing. So that is one big difference that I've seen in pleadings in India and abroad. And once you finish the pleading stage in an international arbitration, I think you get to a stage called disclosure. In India, we call it inspection of documents. And what generally happens is, you would go to the other side, ask for the originals, you will compare the originals with the photocopies that have been annexed to the pleadings, etc. But what doesn't happen is that you can't ask for documents from the other side. So there is no production of document stage. Only you can probably, so the parties can put in whatever documents they want to rely on, and they can keep back documents they don't want to rely on. So I haven't really seen an Indian domestic arbitration where I've taken the opportunity or given the opportunity of disclosure and production of documents where I have asked for documents from the other side. So that is very different than in an international arbitration, where it is a given that in a disclosure stage, the other side will have to produce documents that are adverse to them. And so would you. You would also have to send documents or file documents that are adverse to you, because it is expected in an international arbitration in a disclosure stage. So what happens is, in a disclosure stage, in an ICA, you generally do it in a tabular form, which is called as the red font schedule. And I'll show you how it looks. So this is a specimen red font schedule in front of us. It was prepared by Mr. Redfern, and therefore it has his name. What happens is, it's a tabular form, and you will see the first column is a request, the second column is reason for your request, and response to the objection. And then the third is an objection, and fourth is the tribunal's decision. You can sort of change the titles a little bit. So the request and reason for request can be one column. The third column can be objection by the other side to the request, and then the fourth column could be a reply to the objection, and then the fifth column is your tribunal's decision. So if you see request 1 here, you can ask for all documents relating to sale or distribution of the respondent's product. So there's a category of documents that you ask, and the requests can be from anywhere, request 1 to request 30 or 20 or 5, it depends on you. But you essentially ask for class of documents. You give a reason for why you want those documents. Now, it can't be that it can be a mere fishing expedition because you just want to see if something comes up. You have to give a proper constrained reason as to why those documents that you're seeking are relevant to your arbitration, and what you're seeking also needs to be proportionate to the dispute that is between the parties. So you give a reason for your request. The other side gets an opportunity to respond and say, no, what you're asking is just too broad, it is not relevant. essentially what you need to give reasons as to why you don't want to give those documents, if you don't want to produce those documents. And then the other side gets an opportunity to reply. And then if you see, the last column is the tribunal's decision. So it is in this one table itself that the tribunal will say, okay, give these documents, don't give these documents, and if yes and no, why. So at the end of the day, this is one table for one side. Similarly, there'll be another table for the other side. So their request, your response, their reply, and the tribunal's decision. And then, so this is your stage of the red form schedule stage is what we call it. And then comes the stage of production. So after the tribunal gives a decision as to whether or not documents need to be given, then the parties need to take about a few weeks to sort of collate all of those documents under various classes, and then they disclose it. So this is a stage which is not generally it's not generally there in an Indian arbitration, but I think it's about time we introduce it, because in an Indian arbitration scenario, it's quite important that, what we get because of this stage is documents which the other parties held out and not disclosed in an arbitration, to which you will not have access to. So it is not just their correspondence with the other side, but it's their internal correspondence, how they're reacting to your emails. So everything that is related, whether it's internal documents, external documents, everything must be disclosed. And I think it's very important that this stage happens even in India, because then it does severely impact your award at the end, when you know what was happening internally when the dispute sort of arose. So just to give you an example about this, so if it's a sale of goods contract and there's a problem about quality, and you're saying, the goods that you gave me were of, inferior quality, and the other side's disputing it. But after a disclosure stage, if you get emails where they're internally discussing, it's bad quality, but let's just sell it anyway, then, that's your smoking gun which you can use. But without this stage, you will never get that document from the other side, because the document, they will never produce it, right? So, which is why the stage of disclosure is quite important. So it's only once this disclosure stage happens do we actually get to the stage of filing affidavits of evidence or witness statements that you spoke about. So it's pleadings, your disclosure stage, then your evidence in an arbitration. And then you get, once your evidence is filed, then you get to the stage, you get to the pre-trial stage and the trial stage. So in an evidence stage in India, what you file is your affidavit of examination in chief. And there would be either those are filed simultaneously by both parties at the same time, or they're consequential. So the claimant will file first and then the respondent will file first. These affidavits are, of course, notarized. If there's any electronic evidence that you're filing, I think the Indian Evidence Act requires you to file a certificate of Section 65B for electronic evidence. All of this is just done away with in an international arbitration. You don't have notarized affidavits, what you call as witness statement. So you will have a witness statement, which is similar to an affidavit, of course, but you don't have to prove a document. So in India, when you're filing an affidavit of evidence, you will go through each disputed document which happens in your admission and denial stage. And if a document is disputed, you will say that, I'm the author of the article, or I sent it, and therefore it's true and correct to the best of my information and belief. All of that doesn't happen in witness statements abroad. I mean, documents are proven to be right unless somebody objects to a particular document. So you don't lead evidence as to documents. What a witness statement will do is just tell a story. So a witness statement is not a repeat of your pleadings. It sort of substantiates your pleadings and gives a story of what actually happened. So that is how it is different than, other than, of course, the formal requirements of, notarization, etc. Witness statements are drafted also very differently than an affidavit of evidence in India. Also, at the end of a witness statement, you'll have something called a statement of truth, which the party will sign, and that is enough. So The tribunal, the other side, everybody believes that if you file a statement of truth and at the end of it, everything what you've said is true and correct, you don't need a separate notary stamp, or you make it in a form of an affidavit to prove that what you're saying is right. So that's just the general difference. Just one more thing to point out, that there are sometimes arbitrations which are only document only arbitrations. So your award is decided based on your statement of case. So, for example, your particulars of claim, defense, reply, and the documents that you file with it, that is it. Your arbitration closes and you get an award based on the documents, because the tribunal doesn't believe any witness evidence or cross examination will really affect the award in any way. So a lot of commodity arbitration, such as the London Metal Exchange, or the Refined Sugar Association, or GAPTA, for example, all of the arbitrations under those institution rules tend to be document only. So there are no evidence that is really filed, and there's no cross examination unless the parties want it. So automatically they're document only until one party seeks an oral hearing or an oral request. So it's at the your arbitration closes at the close of pleadings, and you get an award based on documents. So there's no witness evidence stage in those documents. But in a general arbitration, of course, you will have witness statements and evidence if it's not a document only arbitration. So that's a slight difference.
Well, that's in fact a very important difference that you pointed out, that purely on the basis of documents, where evidence is not let, the outcome of the arbitration is determined.
Yeah.
And then you have to
Yes.
seek permission from the tribunal in case if you want to. I think that
Correct, correct. So if one party wants an oral hearing, then you need
they
to
need
write to the
to.
institution or the tribunal to say, I want an oral hearing. And that is of course granted, but it is up to the parties to ask for one.
Unless
As
there is a
because
specific objection on any particular document wherein the authenticity is questioned, then only an
either
evidence.
documents, or if there is a gap in documents, and if the parties think that the documents are not doing justice to the dispute and something happened orally, for example, if there was like an oral variation of a contract or something which is not in the documents, which is not recorded in the documents, and you want to say that no, but I spoke to the other side and they said it's okay if I deliver 5 days late, and
Hmm.
that is not a part of any correspondence, then you would want to lead evidence, right, about it, and sort of put in that, I
Hmm.
had a call with so and so and we discussed so and so. In that case, you would want to put in evidence, and that is generally allowed by the tribunal. But if everything that you want to say is a part of the documents, then this whole stage goes away of evidence in a lot of these commodity arbitrations.
Correct. So now we've covered interim hearings, we've covered pleadings, the content of pleadings, etc., disclosures. Now we've also covered affidavit of evidence, written statements, document the importance of notarization of documents. Then we also spoke about pre-trial process in detail, wherein timelines are stipulated. Now, lastly, talking about submissions. Anything that you wish to add vis-a-vis opening
Absolutely.
submissions and the oral closings that lead to
Yes,
the
yes.
word passing through?
So the way a trial is conducted is very, very different in India in an ad hoc scenario, or maybe in an institutional scenario as well, as opposed to how it's done abroad in an international commercial arbitration. So in India, what would happen is, or what tends to happen is that once the witness statements are filed, the tribunal will sort of set dates for cross examination. And then the cross examination will be first of the claimant's witness, then of the respondent's witness. And that cross examination will go on for days and months, depending on how you get those dates and how long the cross examination happens. And the way a cross examination would tend to happen in India is that, as a lawyer, I would ask a question to the other side's witness. There would be a stenographer sitting next to the tribunal. My question would be typed by the stenographer. The witness will answer. The answer will probably be rephrased by the tribunal for the tribunal's benefit if the witness is not coherent. And then that would be typed out by the stenographer. So the process is really laborious and it takes a really long time. And therefore, it takes months to take on evidence. And once that stage is closed, then there will be a stage for final hearing in an in a domestic arbitration, where there will be arguments, citing of judgments by both sides, and then the matter will be closed for an award. But this is not how it works in an international arbitration. In an international arbitration, a trial comprises of your examination of witnesses as well as your final hearing arguments all clubbed together. And depending on the complexity of the matter, the trial can be anywhere from 3 days to 10 days to 12 days or 2 weeks, but it happens on an everyday basis for full days, and it ends in one stretch. So there are no adjournments in between your evidence and your final hearing. So when a trial is scheduled in an international arbitration, what generally happens is that the tribunal will ask for some prep to be done beforehand. So there will be bundles prepared. Now these bundles would tend to either be in electronic form or a hard copy form. It depends on how the parties want it. There will be either multiple bundles, single bundle, but there'll be a bundle of all of the pleadings, there will be a bundle of all of the orders, and there will be a bundle of all of the documents. Now, these documents are from what you've annexed to your pleadings as well as what has emerged from disclosure, which is a huge volume. Not all of or everything from disclosure may not be relevant because you're expected to disclose everything. It may or may not be relevant. So the parties can choose whether the whole disclosure needs to be before the tribunal, or you can pick and choose what you want out of the disclosure and put it in the bundle. So these are what are called trial bundles. And then you're expected to file what is called as a trial skeleton, which is an opening skeleton before your trial begins. So these are your opening submissions that you need to file in advance in a written form with cross references to documents, and those cross references are by way of bundles that you've prepared. So for example, if you're saying that an email dated so and so sent by so and so in your opening submissions, and if that email is at page say 108 of bundle 3, so then you will sort of write 3/page number next to the email. So it is that detailed and cross-referenced and given to the tribunal in advance of your trial, so that when the tribunal comes, the tribunal is prepared with what you're going to be arguing and what the dispute is all about. So once, and all of the timelines for this is also either set out in the first procedural order itself. So you have to think, say, maybe a year in advance as to how much time you're going to take for your written submission, preparing of bundles, all of that in advance. Or else, if it's not decided at that stage, what the tribunal will do is have a case management conference just before the trial. So pre-trial CMC is what they call it. And in the pre-trial CMC, the tribunal will decide timelines for all of this and how long the trial needs, whether you need 5 days, 6 days. If there's any change from the trial timetable in the first PO, then the tribunal will take into consideration all of this. So at the pre-trial CMC, all of this is decided. Bundles are filed, opening submissions are filed, and then when your trial starts, on your first day, you'll have oral openings, which sort of take form of what your written openings are in the first place, which were filed beforehand. So the oral openings can, take about half a day, 1 day, where both sides will sort of open their case as to what their main disputes are and what their main submissions are. Your witnesses are cross-examined, both claimants witness, respondents witness. And in ICA, since the stakes are slightly high, parties tend to opt for live transcription. So there will be a live transcription ongoing. So all your opening submissions are recorded, all your cross-examination is recorded. So the question that you ask and the way the witness answers, there's no room for rephrasing or, the tribunal to sort of change, what the witness has said. So it sort of gets recorded as is and in live format. So even as the trial is going on, the lawyers can see it on their screen, what it being recorded. And then, of course, it's available for everybody to see at the end of the trial as well. So so even if there's a or a pause, the live transcriber will type there or a pause there. So it's recorded in that detail. But it also means that your cross-examination is very efficient because there's no pausing for the stenographer to take notes or, rephrasing or the witness to think. It all happens very quickly. So all in the most complex of cases, your cross-examination gets done in 5 days. Even if it's 5 witnesses, 10 witnesses, it doesn't matter, right? And for how long you want to cross-examine a witness is also decided previously, by the way, in your pre-trial conference. So you have to tell, I will cross-examine this witness on this day for maybe half a session or 1 day. So everything needs to be prepared in advance. You can't just keep cross-examine to your, whims and fancies, and not knowing how long this is going to take. So everybody's sort of given a timetable and everybody needs to stick to this timetable. And once the witness cross-examination is done, immediately your oral closings start. So you have to sort of make your final arguments along with the law at the end of the cross examination in the same trial window. And once that is done, the tribunal allows you to file written closings, and those written closings can be filed depending on the party's convenience, maybe 2 weeks, 4 weeks, a month after the trial. And after that, your award comes. So it is all extremely structured, you will see, as opposed to in the domestic scenario where your evidence stage can go on for as long as the lawyers want it to go, and once that is closed, you will have another session separately scheduled for your final hearing. And then, of course, we also have the closing submission stage in India where you give written closings after the hearing. And then the award, of course, is the same in an IC in an Indian context. I have to add that in an Indian context, you need to stamp an award, which you don't need to in an international commercial arbitration. So yeah, those are some practical differences that I thought I should share with you all about how things work in India as opposed to how it works abroad too.
So to all the viewers who are watching, what is common between a school and an international arbitration? It is strict timetable that you have to adhere to. So on that note, anything that you wish to add, towards the end, because now that we've approached the end of the segment, so anything that you wish to add to our session?
I think what I will say from my experience practicing in both countries is that practicing in India teaches you to think on your feet, because you don't know when you're arguing in court or even in an arbitration, you don't know what judgments the other side's going to cite. You just get a copy of it while, the other side's arguing. You need to come up with a response, distinguish the judgment right then and there. So practicing in India teaches you to think on your feet, whereas practicing abroad, you're given everything in advance. So when I speak about preparing bundles and giving your written opening submissions before trial, you also have to give all your judgments, prepare a bundle of authorities much in advance and give to the tribunal, so the other side knows the facts as well as the law that you're going to be arguing beforehand. So it's sort of, you don't have to think on your feet last minute. But what practicing abroad teaches you is efficiency, teaches you detailed, like the details that need to go into your written submissions and your oral submissions, and the preparation that goes for a trial is far more in international commercial arbitration, and the time that you spend is far more as opposed to practicing in India. But I think both have their own advantages and disadvantages, and I have to say that the thrill of practicing both is the same if you love your disputes.
Well, thank you so much, Chinmayee, for taking our time for this brilliant session, for sharing your valuable insights. I only have one thing to say. I have been recording sessions for a little over 2 years now, but here is an accomplished speaker for the first time on our channel who has excelled in a particular area of law in two different geographical locations, two different territorial jurisdictions, both in UK as well as in India, particularly in Mumbai. So thank you, Chinmayee. It really means a lot to me and my entire team. You for sparing time and doing this really very important topic. The comparative analysis that you did between institutional international arbitration and domestic arbitration through with the help of the PowerPoint presentation as well. So to all the viewers who are watching, I'm sure 99.99% of the queries must have been solved by now. But in case if you still continue to be stubborn, then feel free to write to us. Our email is mentioned on the channel, and feel free to mail. We'll be more than happy to forward all your queries to our amicus for today's session. Chinmayee, immediately means a lot. Anything that you wish to say as parting words before we wrap this up?
Thank you very much for having me, and apologies for rescheduling the last time. But I'm very, very grateful to be a part of this channel, and I'm always available if you or any of your viewers have any queries. Feel free to reach out to me, and I'll be more than happy to share my views.
Fantastic. I think that is pretty much it. So next session is also on its way. Stay tuned. Please like, share, subscribe my channel. It's goodbye for now.
Thank you.